Hello. Hi.
Hey, good morning.
Welcome. Dean, thank you for joining us.
Oh, it's my pleasure. Thanks for having me.
Yes, thank you for waiting patiently. We've been running a bit behind time, but here we are. Would you please go ahead and introduce yourself? Tell us where you're from and what it is that you do.
I am Dean Tong. I'm a forensic trial consultant, expert witness in the United States in high conflict divorces, child custody battles, contested child abuse cases, all courts, family, juvenile, criminal, appellate, post-conviction, evidentiary. But I've been doing this for 25 years professionally. My website's abuse-excuse.com. I'm a published author. I've written 3 books on the subject.
Mm-hmm.
My main focus of concentration is false allegations of child sexual assault, which of course, in my opinion, is the most egregious and acute form of parental alienation.
Yes, yeah. So that's used as the starting point for the alienation to take place.
Yeah, so if you look at the SAID syndrome, which is chapter 8 of my book, Elusive Innocence, that was published by psychologists Blush and Ross out of Michigan in 1987. The false allegations of child sexual assault within a high conflict divorce, custody battle, visitation dispute, the child is wielded as a pawn, weapon, or tool for the purpose of gaining custody. So especially young kids are very suggestible, very impressionable. Could talk about how daddy touched my pee-pee, but may be mistaken if you look at the studies by Dr. Stephen Ceci in his book, Jeopardy in the Courtroom. You understand that the emotional, psychological, mental aspect of this to the children is most easily executed when the child is used as that pawn. And children can say things to child forensic interviewers, CPS, the police that just never happened. Not that they're lying, but that they're mistaken. So the emotional case of abuse is more the meek and mild for me. You had some questions that you were asking your interviewees to answer. Is it accepted science and law in my country? It's a Las Vegas crapshoot. So basically, it's not published in our DSM-5, which is our Bible of mental health disorders.
Yes.
It is in there as subtypes: estrangement, child psychological abuse, parent-child relational disorder, and child affected by parental relationship distress.
Yes.
But it's not in there as alienation. In my opinion, the reason it's not is because the DSM-5 committee, which basically are the decision makers on what disorders are published in that Bible, if you will, think that this is a malicious weapon, that children are being weaponized maliciously in divorces and custody battles for the purpose of gaining custody. So I don't ever think that the word alienation will ever be published in the DSM-5 or the DSM-6 or whatever following DSM body of authority is going to be published in our psychiatric community. Dr. William Bernay has been our most outspoken expert on the issue here in America. He has come up with this 5-factor model for parental alienation. I have several cases anecdotally that can basically describe that 5-factor model where the children and my clients are the victims of the same. Most recently, the case of John Mast. He was my client. I testified in that case as an expert 11 months ago. John was recently murdered in the state of Idaho in a horrible case of alienation. And unfortunately, it was a case of justice delayed as justice denied. The courts were very slow in ruling. The lawyers were very slow in trying to get the mother and the mother's parents, the maternal grandparents, psychologically evaluated. That never happened. So instead of John meeting his kids on February 5th, 2021, he met a 9mm Glock and was shot several times and killed. So it's very serious. It's a very serious issue. It's an issue that I take personally and professionally because, of course, I got started in this in the mid-'80s as I was falsely accused too out of a divorce in 1985. So basically, I try to induce attorneys to intersect the 3 most important dots of a case, which are the facts, the science, and the law.
Yes.
And try to help them with expert opinion, also questions to impeach the credibility of opposing fact and expert witnesses at hearings and trials. The law in our country that governs admissibility is parental alienation, whether it's junk science or genuine science, is Fry Daubert. The law in Canada, north of me, is Mohan. So they're very similar. They require the issue of parental alienation to be published, to be peer reviewed, to have a known error rate, to be scientifically reliable,
Yes.
and to be accepted by the general psychiatric community. And that's basically the factors that the court needs to admit the science. But then the court needs to know, is there a tangential effect of the alienation on the child victim? So do we have a child that's suffering psychosomatic issues, headaches and stomach aches, nausea, vomiting? Do we have a child who's depressed, who's angry, who's scared? Do we have a child who's maybe a teeny bopper, has gotten to the level of self-mutilation or suicidal ideations? And so these are all issues that have to be considered for the court, by the court, in whether the alienation is admissible science and whether it's affecting the child, because of course the law here in my country is the best interest of the child. It's not about the accused, it's not about the accuser, it's about the kid. So tomorrow, it's a very sad and tragic day for many, as National Parental Alienation Awareness Day. People who have been victimized by this issue, who haven't seen their kids, they've been separated for weeks, days, months, and years. Some of my cases, go on in longevity for years, 3, 4, 5 years until they conclude. So you do get separation anxiety as a main issue with the child victims. I encourage anybody who's involved in a case to archive and keep your messages on your parenting app, OFW, Talking Parents, app close. Keep your messages from text messages, emails, posted social media, letters. All that stuff can be legally admissible into evidence onto a court record to help you in your own case. So very important. The competency level or the effectiveness of attorneys who litigate these cases, that needs to be upgraded. That clearly needs to be upgraded. So I encourage attorneys to, read Dr. Cece's book, Jeopardy in the Courtroom, read Dr. Warshak's book, Divorce Poison, follow the work of Dr. Jennifer Harman, Harman in my country out of Colorado. Follow the work of Dr. Edward Kruk, Kruk, out of Canada. Children Held Hostage is a great book by Rivlin and Claywar. You got to do your homework in these cases. They require a lot of time. And as a lawyer, you have to devote that time to your client and to the needs of the child victims.
Interesting that you said you don't think parental alienation will ever be admitted to the DSM-5.
I don't with the word alienation, Sinta. I believe that the committee believes that the very word intimates vindictive, malicious intent on the part of the alienating parent against the targeted parent. So I think the verbiage is very it's very tricky. It's very meticulous. I think that needs to be refined. I don't know, and look, I was very close to Dr. Richard Gardner, who coined this phrase in 1983. He and I spoke at conferences together. We were associates back in the 90s. Dr. Gardner died in 2003. If we have to change the very words parental alienation to parental estrangement, whatever you have to change it to, I'm not that definitive guy who's going to be the one who's going to be lobbying the legislature and the judicial committees on what this verbiage is supposed to be, the DSM-5, the DSM-6 committee. But I clearly think the word alienation rubs the decision makers the wrong way.
Yes, but the alternatives that are being used lately, coercive control and those, what's the other? They might be more successful.
I think, again, you use the word coercive or coaching or pressure, manipulation. I think the verbiage is very important. We got to get that right. I don't know what those correct words should be. I think the talking heads, the academics, Dr. Bernay, Dr. Harman, those are the people that need to decide what is the correct verbiage? But I think alienation rubs the decision makers the wrong way that head the DSM committee.
Yeah, very interesting. And you've shared some information about a very tragic case recently.
John Mast.
Very, very tragic case, and it also was dragged out too long. Are there any other stories or particular details that you could maybe share with us that could be helpful to people who find them in a situation like this?
Well, look, I just think people, and I understand about finances and money being a very important issue in these cases, because unfortunately in America in family court, you get as much justice as you can afford. So to hire experts like myself, like Dr. Bernay or Dr. Warshak or Dr. Harmon can get very expensive. But you think about it, and the attorneys are the ones charging you for time on the phone, text messaging, responding to emails. We don't do that. At least I don't do that. Yes. So I think it's very important. Go to avvo.com, avvo.com, to look up the legal reviews of your attorney. Okay. You need to have a line of questions. There's a section in my book, Elusive Innocence, a section at my website, abuse-excuse.com, how to choose your attorney. Very, very important.
Yes.
Perhaps the most important decision you're ever going to make, to try to help not only yourself, but your kids. So your lawyer is representing your children indirectly. Even though the children may have minors counsel or a guardian ad litem, it's really the accused attorney, the targeted parent's attorney, that has to represent his client or her client directly, but the children indirectly. Yes. And you have to know that going in, and look, these lawyers need education. They need help. Oftentimes they reach out and they'll tell their client, I need an expert to help me propose the questions to impeach the opposing fact and expert witnesses, whether that's CPS, sex crime detective, therapists. In my cases, we get a lot of therapists that are involved who are well-meaning, well-intentioned, but perhaps misguided. And they'll start treating a child as an abused victim immediately before a court has made a finding of fact, conclusion of law that kid has been abused.
Yes.
Well, that's like treating a kid for cancer with chemotherapy or radiation before a lab or physician has diagnosed that kid with cancer. You can't do that, but they do it anyway. In my state of Florida, they have what's called an SATP, Sexual Abuse Treatment Program. So any kid who's allegedly been molested is going to go into this sexual abuse treatment program, and their memory is going to be reinforced and convinced that this is what happened to them. Okay, so now we're getting into suggestibility and memory. Yes. And memory is not a perfect video. It deteriorates with the passage of time. You can get what's called schemas that can develop, which can alter and modify memory. Yes. So you lose your implicit unconscious memory, and the kid is going by his or her recognition explicit memory, controlled by the amygdala and hippocampus, and that can be modified. That can be altered very easily and contaminated. So most of my cases, Sinta, are he said, she said, what a child said, what we call child victim hearsay. There's no medical findings, but all you need is the word of the kid to cause the targeted parent to be arrested, and or an injunction filed against, and or that kid being taken away from the custody of the accused, the targeted parent.
Okay. Dean, it's very complicated. Please give us some advice. If I'm a parent and I realize, or I even just start suspecting that my child is being alienated from me, what do I do from a forensic point of view? What must I do right from the start to ensure that I'm building a proper case?
Right. So
apart from keeping good record of communication and events, I suppose.
So if it's not an abuse allegation, and if it is an abuse allegation, daddy touched my pee-pee, or the child has a big bruise on his forehead, and you don't know how the child acquired that bruise, your first reaction is going to be, I'm going to take the kid to the ER or the local clinic, and that can be legal suicide, because that doctor or nurse is a mandated reporter. They can turn you in if they believe You actually caused the bruise, or you failed to protect the child who's been bruised and been abused. So be very careful, because this is a government that works in loco parentis, parens patriae. The state is the parent. This is not the government helping you, the accused. This is the government looking out for that kid.
For the child, yes.
But on the issue of alienation, you want to document, like I said earlier, keep a log of your app messages on OFW, Our Family Wizard, text messages, and posted social media, emails, where the alienating parent could be denigrating, berating, vilifying you, the targeted parent, in front of the children. Maybe the children are chiming in and saying, "Hey, Daddy, you're a jerk. Mommy told me you are." So that would be, we're getting into now, according to Dr. Gardner, we're getting to that severe parental alienation phase, okay, where, of course, the child is repeating, parroting what the alienated parent's saying. And then eventually the child is going to suffer from the same fixed and rigid belief system that the alienated parent suffers from, and is not going to want to see you, is going to reject you, regardless of what the court says. The kid doesn't want to see you. So now you're in that severe, you've jumped from slight to moderate to severe alienation phase. And now, Houston, we have a major problem.
Yeah.
Your lawyer doesn't know what the heck to do, doesn't have a theory, doesn't have a strategy moving forward, isn't guided by an expert, because you don't have an expert, and therefore, is relying on you, the targeted parent, to give him or her advice how you want to litigate and try this case going forward. So make sure you, the targeted parent, author a timeline, a journal or chronology by dates and events. Very, very important. Okay. And then, when you get into court, you want to start doing aggressive discovery. What I mean by discovery is getting all the documents. So the kids' medical records, mental health records, school records. You want to file for interrogatories of the targeted, or rather the alienated parent. You want to file for what's called request for admissions of the alienated parent. You want to file for a deposition, which is interrogatory questions under oath of the alienated parent by your attorney. Okay. The lawyer may need help in fashioning questions to impeach the credibility of opposing fact and expert witnesses against you, representing the alienating parent. So this can, in my cases, oftentimes boil down to be a battle of the experts, where I go up against an MD psychiatrist, or I go up against a PhD psychologist. And I've done this multiple times in court. And obviously, again, we're getting back to dollars and cents, and it gets expensive. In cases where you, the accused, are facing juvenile court for coaching or failure to protect, or being a false accuser, allegations of that, you're falsely accusing the other parent of abuse, and you're in juvenile court against CPS, or you've been arrested, worse, in criminal court, my services can be retained at no cost to you, the targeted parent, the accused. The judge will order the state to pay my fees so long as you are indigent, you are poor. Okay, yes. In law, that's called informa pauperis, IFP. So I agree with you, Sinta. These issues are very complex. They are very involved, and oftentimes over the head of the layperson. I advise you to make sure you have a competent team, a defense team that knows what they're doing, and can obtain for you the equity at law in court you are seeking. I also advise parents, do not air your dirty laundry or scan in court documents onto Facebook or any social media, because that stuff can come back to bite you. It is all legally admissible into evidence onto a court record. So be very, very careful there. Yeah.
Talking about what's admissible, just a practical question that I find often with parents with very young children who are not, for whom it's not age appropriate to really interview when they're really small. You're having a conversation with your child, and your child is revealing some damning information about the alienating parent. Is it appropriate to record them? Just grab your phone and record what they're saying?
Right.
Or is it...
You want to check in America, in our states, we have taping laws, okay? So in my state of Florida, for example, we are a two-party state, meaning you have to obtain permission from the other party to tape. Now, obviously, a 4-year-old child, for the most part, is not going to be able to give you permission, right?
Yes. Yeah.
So look, these are reactionary measures that are executed by the targeted parent. You believe you've been alienated. Your child is exhibiting signs and symptoms and behaviors of an alienated child. What else can you do but wear a body cam and or tape that kid with your cell phone? I suggest you do that with the knowledge that what you're doing may be inadmissible back in court, depending on the laws of your state. States like Arizona, New York, I believe, are one-party states, so you don't need permission to tape the child, to tape the alienated parent even. You don't need permission. But whether or not your attorney is going to use that in court to your behest, that's up to the lawyer.
Yes, okay. All right. Yeah, so it's gathering information and keeping proper record of everything. That's the starting point, and
Right.
that's going to help you through towards the end.
Right, right, and that includes any signs or symptoms or behaviors of your child. So bedwetting, which is called enuresis, nightmares or flashbacks, or curling
any
up
kind
in
of regression.
Regression, right? Curling up in a fetal position, baby talk, thumb sucking, anything like that. You better start going to psychologytoday.com and looking for a therapist. And if it's a very young child, you want to look for a play therapist, and especially an RPT, registered play therapist. Okay.
Yes.
So there are two types of play therapy. We have directive and non-directive. So directive, the therapist is guiding the child with the dolls and the puppets and the drawings, and non-directive, the child is doing it of his or her own free volition. But it's not just what you know, it's who you know. So you have to get the kid into the right trauma play therapist. If you believe the child is a victim of trauma, by the other parent or the other parent's family, you have to choose, just like choosing the right lawyer, you have to choose the right therapist. There is a website I want to add, Sinta, and that is a4pt.org, a4pt.org, and you can find a registered play therapist at that website. That's the Association for Play Therapy, right?
Yes, interesting. Thank you for that. We're going a bit over time, but if you will allow me to ask you one more question, please.
Sure.
Where do we stand in terms of recourse against the alienators? Do they still just get away with it?
Well, no. I mean, look, some of my cases involve Title 42 USC 1983, which is our federal code to file lawsuits for damages against false allegations and alienating behaviors. So I do highly recommend people who have been falsely accused of abuse, where charges have been dismissed by the police after they've been arrested, or the state attorney, the district attorney's office, or the court. Judges who make findings of fact, conclusions of law, such as what was made in my client's case, John Mast, who was murdered. He was cleared of all abuse allegations with my help, but unfortunately, he did not get a good judgment from his judge on parenting time. He was relegated to a Disneyland dad visitation rights, and like I said, when he finally came up to see his kids, he met a gun instead of his kids. But so I do encourage you to consult a civil rights attorney on your opportunity or chance to sue for monetary damages, the alienators, the false accusers in your case.
And I believe a prior interview that I had a bit earlier this afternoon, also the gentleman said that in general, he finds that people don't pursue it beyond that. They're so exhausted and overextended with the parental alienation battle that once they manage to get their children back, they just let everything else go, and they just seem to carry on with their lives.
Yeah, I totally get it. You have two choices. You can either dive in with your whole body, as I did after I was cleared in 1986, 35 years ago. I went on to become an expert in this field, or you can run for the hills and hopefully get the best parenting time order you can get, understanding that you can be in the thick of litigation until those kids are 18.
Yeah, true. That's the sad reality of it. Yeah. Well, thank you so much for your input and participation. I really appreciate it. And I will be in touch with you for doing some more of this, I hope, in the very near future. Yeah.
Thank you, Senator, and